So this afternoon, once again, we have Faye Luppi from the oh my gosh, the Violence Intervention Partnership in Cumberland County. And this is part 2 of our 2-part series with Faye. Today, she's going to do a deep dive into the ODARRA, which is statutorily mandated pretrial risk assessment tool specific to domestic violence. So I will turn it over to Faye.
Okay, thank you, Kara. I know Amy and Cindy heard some of this last week, so forgive me for a little bit of the repetition, but I just want to introduce myself a little bit. The Violence Intervention Partnership is Cumberland County's coordinated response to domestic violence and sexual assault. And I've been doing that work now for 22 years. So as part of that, I was trained as someone who could use the ODARRA, and then trained as a trainer in 2007, 2008, when parts of Maine first started using the ODARRA. So we'll talk more about about the process in a few minutes. But as I mentioned last week, also some of you, I was a prosecutor before that, so that you'll hear that prosecutor voice come out occasionally, and it is in part because I have been very careful as we have adopted this risk assessment tool to make sure that we are that our work is consistent with the research on the tool, so that prosecutors, law enforcement, others can walk into court and rely on the fact that this is evidence-based, it's validated, and we adopted it according to the research. So some of what you'll see is, talk about this is what the research showed, and we don't have research about, this next step yet, but they're working on it, things like that. That being said, I'm going to, is it set up so I can share my screen, Kara? Okay.
Yes, it should be all set.
I will pull that up, and there we go. So this is what I'm going to be using here. These slides are slides that the Maine Coalition to End Domestic Violence and I helped put together, so that we would, and again, this is part of how we implemented it, so we would have consistent training, consistent message, consistent materials around the state in whatever refresher trainings we use for law enforcement, or that they're all consistent. And I think that's been a really important part of how we implement this tool. And I think I know Amy and Cindy were here, but for those of you who weren't, ODARRA is the tool that Maine adopted that looks specifically at the offender's likelihood of reoffense. And in the last session, we spent some time talking about the tools that focus on the victim's likelihood of being killed, of lethality. And those are two different arenas that complement each other, two different assessments that complement each other, although there are some overlapping parts, and I will talk about those. But what we're going to talk about today is reviewing sort of Maine law and new developments, an overview of ODARRA, some of the updated ODARRA scoring. One of the reasons we adopted the ODARRA was because it does allow scoring if there are some items that are ambiguous or unclear, and we'll talk about that. And we'll talk about, and I hope to spend some time on this, interpreting and documenting and using the ODARRA and how it might come up in your work. So if you have specific questions or a case that you wanted to talk about where ODARRA was an issue, or you want to know more about how do we use it, please ask a question as a small group or type it in the chat, and Kara's going to keep an eye on that, so that we can have this answer whatever questions you have about ODARRA and risk assessment in Maine. So I'll start with some of the laws so that you have a sense of what they are. I covered a couple of them in the last session, but I think it's important to know what the laws are around risk assessment in Maine, because I think we were the first state to adopt risk assessment statewide by legislation. There have been some others that have since then adopted various tools, but I think we were right at the head of the pack. So as of 2015, law enforcement officers have to make a good faith effort to administer a validated evidence-based domestic violence risk assessment tool recommended by the Maine Commission and approved by the Department of Public Safety. So you'll see there's some parts in here, and good faith effort we'll talk about in a little bit, but sometimes, as you might imagine, there are situations where law enforcement officers can't get the information they need to score the ODARRA, which is why it says good faith effort. And it doesn't specify ODARRA in the legislation because if there was something better that came along, we wanted to be able to adopt it without going back and changing the legislation. So basically, we spent a year researching risk assessment tools, created a report for the commission. The commission adopted it, made those recommendations to the Department of Public Safety, and then those recommendations were made to the legislature, and it was adopted. So it was quite a process, and I think that has also helped in ensuring that it is accepted in the courtroom. Initially, of course, some of the attorneys kind of said, oh, this is junk science, and it's not. I mean, it's peer-reviewed literature. It was adopted after a long period of study and assessment, and that all helps. And then the law enforcement officers administering it shall provide the results to the bail commissioners and to the district attorney in the county in which the abuse took place. So hopefully, as victim witness advocates, when you see the police reports, the ODARRA score sheet is part of that. And because that was the intent, was that that the bail commissioners get this information. So generally what happens is when law enforcement drops somebody off at the jail, they have to provide the ODARRA information to jail intake, or if they're lucky and they work in a smaller community, the bail commissioner is right there and they can provide that information directly. But in Cumberland County, that's not how it works, and so the jail intake staff, we actually trained them in terms of not to how to score it, but in terms of what it means and what they should be collecting, so that they can give that information to the bail commissioner to set bail with more informed information. And bail commissioners, and again, so this was a big step, may not set bail in a DV case without making a good faith effort to obtain, the results of the ODARRA. So what was happening, was that, there was some pressure in terms of from the jails in terms of getting that information provided, because the bail commissioners can't set bail by law without it. Inappropriate cases, and we'll talk about that in a little bit, because one of the issues that has come up around ODARRA is that it is validated for certain domestic violence offenses, but not all of them. So we'll talk about that in a minute. And again, the judges have to take into account evidence that the defendant poses a danger to others, to the safety of others in the community, including the ODARRA. So the judges ask for it. They are required by law to take it into account when they are setting bail or making other decisions. Okay, so we did talk about this a little bit last week when we interrupted it, but I'm going to go over it again. So ODARRA is the Ontario Domestic Assault Risk Assessment tool. It is an actuarial tool like health insurance, life insurance. It's based on statistics that indicates the likelihood that a male or female offender who has already committed an assault on a current or former heterosexual, intimate, or dating partner will do so again in the future. So as you can see by the language, it is not validated for sort of non-binary relationships. It has not been tested with juveniles. There are, the developers of the ODARRA are trying to collect information about cases that don't fall into this criteria, but they don't have enough yet to make for a big enough data pool to draw conclusions from. So So this is what it does. It doesn't, unfortunately, help the officers in determining whether somebody should be arrested. I mean, wouldn't that be a great tool? They use the predominant aggressor analysis and probable cause and so on. ODARRA doesn't help with that, and I make it really clear to them that that is the case, that the ODARRA is to be administered after the arrest decision has been made. It does not determine whether one partner in a relationship is abusing the other, doesn't take the place of predominant aggressor. And it's not designed, as I was talking about last week, it is not designed to predict lethality, but it was significantly related to outcomes in samples that later looked back that did include homicide. So basically, where there were cases of domestic homicide, the ODARRA scores were the highest. So there is some relationship. Kara, is there a question?
There was a question in the chat,
Okay.
which is when we're talking about dating partner,
Mm-hmm.
the question is, doesn't it have to be a sexual partner? Sort of what's the definition of dating partner?
It does not. It does not. According to the research, that's a really good question, because we have some definitions in Maine that do require that, like for the protection orders and things like that. But dating partner, the developers trained us this way. It's the toothbrush rule. If one of them is keeping their toothbrush at the other's place, they're dating partners. But it's a dating relationship. It's kind of, when you see it. So it does not require them to be sexual partners, according to the original research that this is based on. And it was originally only validated for male offenders on their female current or former spouses. But there was additional research in two areas, one that validated it for female offenders and male victims, and also that validated it for dating partners. So that's a good question. Thanks for asking it. I think it clarifies that, because some of the law enforcement who took the very first original training, it wasn't yet validated for female offenders. And that is, I was so glad to see that research come out, because I didn't really want to be facing a equal protection argument. Well, how come you can use it for these, for men and not for women offenders? But so I'm really glad that it has been validated for both. So what does it predict? It not only predicts any new partner assault. So the higher the score, the more likelihood that the person is going to be reassaulted. But the higher the score, the greater number of new assaults, the more severe the injuries, the more serious the charges, and the sooner until reoffense. So it predicts all those things. So when we get to the chart that shows you the scores and so on, just keep this in mind, that it predicts not just that the person is going to be assaulted, but potentially the severity and the frequency, and how soon it will take place. So why did we pick ODARRA? As I mentioned, there's a lot of different tools out there that you may have heard of, that focus on assessing risk in domestic violence cases. So one of the areas, and again, this was a sort of a joint process with the Maine Coalition to End Domestic Violence and the DV and Sexual Assault Commission and my project. And first of all, we were looking for something that was appropriate for the criminal justice system, and also that law enforcement could use, and that was a tool that was developed specifically for law enforcement. So they collect the information at the scene. And it also, a lot of the tools and a lot of the things that we do require sort of rest on the shoulders of the victim. Some of the other risk assessment tools, some of the PFAs, reporting violations of bail, all these things sort of rest on the shoulders of the victim. So this tool looks at the characteristics of the offender and the offense and the relationship that makes it likely that the offender will reassault, which seems really appropriate for the criminal justice system. So it's designed for use by law enforcement. its predictive accuracy is the best there is in these kind of tools. And I'll explain that 77% figure in a minute. And it takes approximately 10 minutes, and it can be scored with up to 5 unclear or ambiguous items. So the danger assessment that I was talking about last week that focuses on lethality takes an hour or more. And we know that that's just not going to work in the field. That tool is for use by advocates and healthcare providers to assess lethality. This tool is quick. A lot of it is real objective, which you'll see in a minute. And it's easy to collect the information in general. So that was kind of why. And we were fortunate enough, we had a retired Bates College professor who this was his area of interest in research. And he did a lot of research for us and brought some of the tools to us and helped us assess each one of them and how likely and how helpful they would be. So, I wouldn't get tangled up in this. I am going to make copies of these slides and send them to Cara so she can distribute them to you. But just if questions come up about the reliability. So this is, and basically the first one is really easy to explain. If I score an ODARRA and Cara scores it, we are 95% likely to come up with the same score. That's called inter-rater reliability. As if one person does it, another person does it, and they have the same score. So that's really high. That's really good. Predictive accuracy is, for anybody who took statistics, it's sort of the area under the curve. It's the method of choice among advanced researchers for measuring predictive accuracy. And what you're trying to do is balance like a whole lot of false positives with a whole lot of false negatives. And so this 0.77 receiver operating characteristic is pretty high. So it indicates its reliability. It does not mean that 23% of the time it's not accurate. That is not what it means, because that question is answered. And this was, after having been asked that question by a prosecutor friend of mine in front of a whole lot of other prosecutors, I went to the developer and I asked her specifically that question. And she said the standard error of measurement is 95% of the time, the score you get is expected to differ from the true score by less than 1 point. So pretty accurate overall. This is good data. We have this was the book that Zoe Hilton and her partners wrote. And I think I mentioned last week that there's since been a second edition of the book with updated data and information that came out last December. But this is just if there's questions about prosecutors going into court and expects to be, this is the information. So we're starting to get to, you're probably wondering, so what are all these ODARRA items? What are these 13 items that the officers use to score the ODARRA? And they started out with about 60 or more items and reduced them to 13 items that significantly and independently predicted recidivism. And these have since been shown to be validated in a number of additional studies. And as I said, higher scores predict more frequent, rapid, and serious assaults that lead to more serious charges. But I want to go back to a minute to the question that our prosecutor, who is not currently our prosecutor in Cumberland County, but our former prosecutor, I remember having a very heated discussion with her in the hallway when she told me on no uncertain terms that she was never going to adopt a risk assessment tool that didn't include animal abuse. So the question often comes up with, well, what about strangulation? What about animal abuse? We know strangulation is predictive of lethality. We also know that animal abuse co-occurs often with domestic violence, but there's not a lot of research out there that shows that it's predictive of future assault. So I had to explain those differences to her. And it also doesn't mean that you shouldn't consider those items. Sometimes the fact that a victim wants to stay and protect her beloved dog or cat is a huge piece of safety planning. is a huge piece of decision making for that victim. So it's not that you ignore it, it's that you try to solve that problem in other ways. Same with the strangulation, that you recognize it as a lethality factor, but it is not one of the factors that rose to the very top of those that significantly and independently predicted recidivism.
And Faye, if you could, just in case folks who are new and didn't see your previous session, the Maine homicide review panel has identified a series of factors that seem to be the most common factors when we're thinking about lethality
in terms
Maine.
of lethality. The 5 S's.
Yeah,
exactly.
And I'm wondering if you could, it's different from the ODARRA, and it's we're talking about something different, but I'm wondering if you could just run through those, because it's something really important for VWAs to have in mind.
It absolutely is. And that's why I was talking about kind of this lethality assessment complements the ODARRA. It's not either or, it's both. So the 5 S's, which all are items that are in the lethality tool that advocates use in Maine, the danger assessment. Let me see if I come up with all 5. Carrie, you might have to help me. So first one is strangulation. Second one is stalking. Third one is coercive sexual assault, in the relationship. Serial battering. So they have more than one victim. And the 5th one, so I said stalking. Oh, suicidality. So suicide threats. And we know that, in these homicide review panel reports, when they dig deep into, what preceded the domestic homicide, they have discovered in Maine, on one of the reports, it was 66% of the cases, there had been suicide threats or suicide attempts on the part of the offender. So those, when you see that, that's a huge red flag in terms of lethality. Those are not on the ODARRA, but they are very important in terms of assessing lethality. And sometimes when we talk about these high-risk cases, and in our high-risk team, I'll talk about it in a few minutes, we talk about both. We talk about what's the ODARRA score, how likely is this offender to reoffend, and what are some of the lethality factors that we need to consider that are present in this particular case. And those 5 S's from the homicide review panel are really important ones. And we'll talk again, when I go over the ODARRA items, I'll mention which ones are also lethality factors. Does that do it?
Perfect, thank you so much. Okay.
So when to use the ODARRA? So this is what I said initially, that this is where sometimes there are issues with, it's really important to stick to the research and to know when to use it. So you use it, the officers use it when the incident which they're investigating, where the person being assessed, we'll just say offender, has assaulted a current or former heterosexual, intimate, or dating partner. Assault is defined as, so the first one is how we would define it in Maine, any act of violence that involves physical contact with the victim. But the second one is a little bit different. It adds some more. A credible threat of death with a weapon in hand made in the presence of the victim. So when I talk to law enforcement, I say, okay, so what if the ex-husband calls on the phone and threatens to kill a victim? Do you use the ODARRA? There might be a criminal threatening or terrorizing charge, but no, you don't, because it was not made in the presence of the victim, it was made over the phone. Do you use it when the ex-boyfriend comes over and slashes the tires of the victim or the new boyfriend? No, you don't, because that's domestic violence, criminal mischief. And I can remember one case where a DV investigator early on, she'd just been trained in the ODARRA. She came running into my office and she said, I don't know what to do. I have this case that I know is really high risk, but the ODARRA score is really low. And I said, well, what's the charge? What's the case? And she said, well, it's stalking. And I said, you don't use the ODARRA for stalking cases. It doesn't fit into this definition. So it's important to keep that in mind. And when a few years ago, the MCEDV, the coalition, did a kind of a survey of advocates and law enforcement around the state and asked them, how's it going? Where do you think some of the issues are? One of the biggest issues was that people were trying to use the ODARRA in cases where it had not been validated for, it had not been studied for, like domestic violence, criminal mischief, or like stalking, or some of these other cases. And sometimes the jails and the judges and the bail commissioners ask for ODARRA scores in cases that don't fit this definition. It is fairly narrow. So so that's an important thing to remember. And it's a good thing for you all to know if somebody comes in and says, well, where's the ODARRA score? Like, well, this was a DV criminal mischief or DV stalking, or it was a violation of a protection order that didn't involve new assault. So you don't do the ODARRA in those cases because you don't want to walk into court with something that's not supported by the research. Yeah. There's another component to when to use the ODARRA, and we talked about that a little bit. It has to be an eligible relationship. So if there's a bar fight between friends, you don't use it there. If there's the brothers get into it at Thanksgiving and a neighbor calls the police, you don't use it there because and you don't use it between sort of intrafamilial. If an adult son assaults, it's elder abuse, assaults an elder mother, you don't use the ODARRA because there has to be both an eligible crime and an eligible relationship. So you can see the list, DV assault, DV criminal threatening, DV terrorizing, if it includes the circumstances, not criminal mischief or a violation of a protection order, unless the violation involves a new assault. So is that clear? Because that's one of the pieces that was really important. We had to really sharpen up some of the score sheets and some of the explanatory information to make this really clear, because that's important.
It's clear to me, but I don't know if anyone else wants to chime in.
Okay, I see people nodding, so okay. So what's needed to complete the ODARRA? Either law enforcement officer interviews a victim, or they sometimes score it if, I know in some departments, a supervisor scores it or checks the scoring based on a police report, but that presumes that all the information that's needed is actually in the report and has been collected at the time. Investigate, and suspect criminal history. So that's the other piece. ODARRA should not be completed if criminal history is not available. Now, we've had some discussions about, well, does that include a III? Because we certainly had a case in Cumberland County where we didn't have the III information and it was tragic consequences. But generally, when we do this, understanding that there are barriers, that it is difficult to get a III for law enforcement on the road, because the last I knew, it still required an in-person signature. Usually, unless there's some indication that the person just moved from another state or had lived a long time in another state, we do that. I actually have a question for you all, because this came up in a recent discussion. How easy is it for you to get IIIs? Do you typically get them in DV cases?
I can run them myself. Like, I'm certified to just get that information myself. So occasionally we'll get them, but not consistently from law enforcement. Yeah. So if there's any indication that we should be looking for history, outside of a specific state, then I can run it myself here.
So is it, you mentioned you were certified, and I know you have to be, certified. Is it the same process you use for SBI, or is there an additional step for III?
It was this, to actually make the request, it's an additional step, but as far as the training and the certification goes, it was in the same class and the same certification.
But it is an additional step to get the III.
It is, and the III has to be documented, so we're audited yearly. Yeah,
exactly.
Police comes around, and so anytime you run a III, there's certain information that has to be documented and stored.
Right, and that's someone asked me that question recently, kind of looking at why aren't we running more IIIs, and that was kind of my understanding, but I just wanted to check that and make sure that was the case. So So anyway, so the ODARRA is intended to be administered as part of documenting the investigation. It is not something that law enforcement sits down and explains to the victim. So that is typically a task that either victim advocates, I don't know if you've had the occasion to explain what it means to victims, but that, that is not something that law enforcement is expected to do at the scene, because they're in the middle of documenting what happened and then, clearing the scene and moving on to their next case. So this is when I mentioned legislation requires a good faith effort to obtain results. So these are some of the cases where, where they might not be able to. The victim is hospitalized and not able to talk with the arresting officer. No criminal history is available. Some systems are down. And the victim chooses not to participate in the investigation. And we know that that happens sometimes for various reasons. Now, when the officers can observe and collect a certain amount of information themselves at the scene without having to ask questions of the victim. But this tool was developed for the officers to ask questions of the victim so that they don't have to worry about Miranda and so on. They're not expected to ask the information of the defendant. So this information, and you'll see, and then they're expected to run the criminal history themselves and observe, what else is going on, because you'll see in a minute that there are some questions about children on the ODARRA. So this is when, if it wasn't available, if the bail commissioner says, well, I need an ODARRA, and the officer says, well, the victim was not able to speak, she was hospitalized, went off in an ambulance, I couldn't get the information that was needed, that is an acceptable answer. And it may be that other people who have been trained to do the ODARRA can do it later, but it was developed for use at the scene by the officer at the scene. So the scoring is pretty straightforward. If the item is, each of the 13 items is present, score a 1 if it's there, score a 0 if there's no evidence that it's there, score a question mark if the item is unclear or ambiguous, and we'll talk about that in a minute. So the ODARRA raw score is you just add up the ones, and then the final score is adjusted for any missing information. We'll see that in a minute. But so this is something that is important to understand, because it comes up, not super often, but often enough that it's important. And this is something I have to spend some time with the officers. So as you know, domestic violence incidents are not always sort of discrete incidents. Something will start on a Friday night and then continue into the next morning, and then maybe continue into Saturday night or whatever, and just kind of keep escalating. And then finally law enforcement is called. So the very first item in the ODARRA is, was there a prior domestic violence assault in their history? So the question is, did that assault that happened Friday night, does that count as a prior if the officer gets called Saturday night? And it's sort of this whole continuing thing. So the rule is, general rule, 95% of the time, you count each incident report as a separate incident. So two reports within 24 hours count as 2 incidents. But if more than one incident is reported in the same incident report, i.e. the officer comes Saturday night and the victim is bleeding and says, well, this actually started last night, do you count that prior incident as a prior? And you only count it if it's 24 hours before the incident where the officer gets called and is doing the investigation. So that's pretty clear. It's either 2 reports separate, or if it's got to be more than 24 hours before, if it's sort of this continuing assault, to count it as a prior. Does that make sense? Is that clear?
It does, but I've had a few cases, Faye, where I speak to the victim about a current assault and they tell me about one that happened a month ago. And I've got I have photographs of it. I didn't call the police then.
Yep.
But
to answer your question, I'm going to pop to this and I'm going to go back to that other slide. But to answer your question, it is this language here, which says, you count this if there's an assault which is recorded in an incident report or a criminal record. So essentially, the police either had to have been called or the report has to have been documented in a subsequent police report. Does that, so do you see? So
So that would count, yes, because we would be charging that.
If you would be charging them, if the officer investigated, investigated either both of them separately or investigated the later one and included information about the prior one in there, and it was 24 hours before, you would count that as a prior.
Okay.
Yes. Yep. Okay.
So we changed the ODARRA score.
Okay, that's another really good question. And that's a question to talk about with your DA. Because it's not a problem, from our perspective, from the work that I've been doing and from talking with prosecutors and law enforcement, it is not a problem to have two ODARRA score sheets out there, so long as it's clearly documented why there are two. So if you put on the second one, additional information came to light, at this time that required a change in the score, so that it explains, and then they're clearly dated and so on, and people sign who did it, who did the scoring and everything. And sometimes, sometimes you find out, oh, wow, the victim's pregnant, or, oh, there's more kids than we thought, or, oh, gee, I just ran the III and there's a whole lot more history here than we were aware of. So what you don't want is 4 or 5 of them out there, because then the defense attorney is going to tear that apart, because you don't want, it's like, well, which one's the right one? Why you got 3 or 4 of them out here? So long as you clearly document and clearly explain why you have 2 different score sheets, then that's been my answer, and that's okay with the prosecutors too. But it's something to think about and talk about in terms of your office policy, who gets to change it and in what circumstances. So I'm gonna go back. So in part, this is a general note before we start jumping into what are the items. ODARRA, doesn't include the lethality factors. So when we talked about that at some length last week, and we just talked about the 5 S's. A person with a low ODARRA scores could have strangulation, suicidality, sexual assault, making them appropriate for high-risk responses. A low ODARRA score might also result from an inaccessible criminal history about the offender. Maybe the offender is a new Mainer who just got here from a country where they don't even have law enforcement, never mind criminal records, or a refugee camp. We have no idea what their background is. So those, I think we talked about that a little last week, have to be careful about that. And there are other barriers to gaining information, such as language or cultural barriers. If you think that maybe the victim, has not been in a place to be able to share some things because of cultural issues or fears, keep that in mind. So I want to go to the 13 factors, because you're probably wondering, what are they? So the first one is a domestic incident. And again, this is not our definition of domestic violence in our statute. It is the definition that we talked about, the eligible relationship, where the person being assessed assaulted his or her current or previous intimate or dating partner or the victim's child, and which is recorded in an incident report or criminal record. So it's important that last caveat, because that gives it, a little more credibility. So it has to have been reported to law enforcement, either at the time of the prior assault or in a subsequent report. So you don't count incidents involving pets or property, and you don't count incidents involving strangers or friends or parents or other family members. So that's, so that's basically it. So the only thing, and we're going to talk about this more when we get to unclear, some of you may remember, if you've been doing this work a long time, that DV assault was only a crime itself with that label after 2007. So if somebody's got a prior on their record in 2005, sometime, and it just says assault, it's not really clear which it is. So that's when you use the question mark, and we'll talk about that more, but just keep that in mind. So number 2 is a prior non-domestic assault, bar fight, the victim's best friend comes over to help and gets assaulted, new boyfriend gets assaulted. Those are all prior non-domestic incidents. So it's a person being assessed assaulted somebody other than current or previous partner or that victim's child. And again, and which is recorded in an incident report or a criminal record. Now you're going to see that number 10 is almost identical to this, except for it doesn't require the police report. So we'll talk about that shortly. But so it does not include incidents involving pets or property, but it also it does not include incidents where the victim was the domestic partner or the victim's child. Number 3 is a little bit tricky, but it's really the only thing that's kind of Canadian. So I need to explain it to you. So if the final disposition, oh, actually, I'm gonna clarify one more thing up here. These numbers 1 and 2 do not have to be convictions. They can be in the record as an arrest. So because that's what the original research used, was arrest. So it does not have to be a conviction. So just keep that in mind. So number 3 is, so and this one pretty clearly does have to be a conviction, but it's also not limited to domestic violence. It's any crime for which the judge ordered the sentence to be served to be at least 30 days. So let's think about a typical sentence might be 364, all but 10, and then a couple years probation and a betters program. So that 364, that the part of the sentence that was suspended does not count for this item. It has to be a time that was actually ordered to be served. So they have to have served it. They have to have been ordered to serve at least 30 days. That has to be part of the sentence. So they have to have, and they have to have served some part of it at an adult or a juvenile facility, jail, prison, detention center. Also counts like Riverview, if there was, if there was some kind of a not guilty by reason of insanity or something like that. But so they have to have been ordered to serve at least 30 days, and they have to have served some of it. So if somebody gets out in 25 days for good time, that still counts because the judge ordered them to serve at least 30, and then they got out for good time in 25. Also, as we know from reading the paper these days, there are a lot of people incarcerated right now who are awaiting trial. It is pre-trial time, and many of them may serve 2 or 3 or 4 months pre-trial if they can't make bail, or if there's some reason that they're not allowed to be in the community. That time does not count unless it was specifically included as part of the sentence, i.e. time served. So if they have served, if the judge says 364, all but 60 with credit for time served, and then they get released right then because they've served 60 days, then you would count that 60-day pre-trial time in jail because it was made part of the sentence. Is that clear? Okay.
I had one question, Faye. I put it in the chat box, but
okay.
You had mentioned that if they're arrested for domestic violence assault, that counts. What if it's dismissed by the DA and they plead to lesser charges?
Well, the research was based on domestic violence arrests. So I would say that you still count it if they were arrested for the officer had probable cause to believe that they had committed a domestic violence assault.
But it's not used to elevate it to a felony for a prior.
Doesn't have to be. They were arrested for, right, it's not subsequently used, but this research was based on domestic violence arrests, not convictions.
Okay, thank you.
Okay. All right. So basically the first 5 have to do with like criminal history. Okay, come on, why is it not moving? There, whoops, okay, my computer, yeah, there we go. Okay, number 4 is really easy. Number 4 is a failure on a prior conditional release. So if they were on bail and violated, you score this a 1. If they were blew out, if they didn't obey a probation condition, if they're drinking and they were told not to, you score it a 1. If they violated a protection from abuse order, you score it a 1. If they FTA'd, because that's a court order and they were released and they were told to come back at a certain time and they didn't, that's an FTA, you score this a 1. And it doesn't matter if there's 5 or 6 or 7 of them in their record, you just score it a 1. But if there's anything in their record where they, violated a court order or probation order or a condition of a deferred disposition, then you would score this a 1. Pretty easy. So number 5, 6, and 7 have to do with what occurred at the scene. So, up till now, and actually including these 2, these are items that law enforcement information that they collect anyway. It's either criminal history or what happened. So when I do this training for law enforcement, I'm like, a lot of this stuff isn't new. You're already collecting it. And basically what we're asking you to do is organize it in a way that gives people making decisions an evidence-based reason to, to make whatever decision they're making. So this one is a threat to kill or harm made by the offender at the scene. So it has to be at the scene of the incident that led to the person scoring. So it can't be something that happened like years ago or months ago or another time. So, and it is a spoken threat or bodily gesture commonly recognized as a threat of physical harm to a person. So if they, go, make a gun, or if they, kind of do this, those are gestures that are threats of physical harm, threats to harm or kill. And they can talk about, I'm going to kill the first cop that walks through that door. Or if you call your sister, I'm going to kill her if she comes over here. I'm going to kill you. So the only thing that doesn't count is if he says, I'm going to kill myself. So a threat to commit suicide, while it is a lethality factor, you don't score it here. So the question that the officer might ask is, did he or she threaten to harm or kill you or anyone else during, the incident? So the next one is confinement of the victim at the index incident. And we see a lot of these. Count any act carried out to physically prevent or attempt to prevent the victim from leaving the scene, even if the victim eventually did get away. So it might be grabs the victim's arm and drags him back into the room, blocks the doorway, throws the keys out the window, throws the clothes out the window. We've had cases where, somebody goes running down the street in the middle of the winter without any clothes on because that's what happened and they got out the bathroom window. So those all count in terms of, and it also counts even if the victim did eventually leave, that there was an effort to prevent the victim from leaving. What doesn't count is, you'll see at the bottom of the slide here, you don't count restraint in the course of an assault. So if somebody is kneeling on the victim and punching the victim, you wouldn't count that. That's not a separate act to restrain the victim from leaving the scene. So that's it. So confinement. So again, pretty straightforward. This should be in the incident report. They should be asking these questions when they go, what happened next and what happened next? Well, he grabbed my arm and he wouldn't let me out, or he blocked the doorway or whatever. Sometimes the questions come up about, well, what if he stomped on the cell phone so he couldn't call police? that doesn't count because that really wasn't an act specifically carried out to physically prevent the victim from leaving the scene. Now, it can be counted in a later one, so hold that thought. So number 7 is victim concern about future assault. So this is also one of the lethality factors. And it's based on research that victims are generally pretty good at determining how much danger they're in, except if they've been in a long-term dangerous relationship and the violence kind of gets normalized and they don't recognize how serious it is. But so any statement by the victim indicating concern, fear, worry, or certainty that their abuser is going to assault them or their child again in the future. So this statement has to be made in the report of what happened to law enforcement. And as you know, sometimes a few days later, if the detective goes back or you are talking to the victim says, oh, no, I'm not worried at all. No, I was just, no, that was a mistake. You count what was said in, that night. And the only time that you would count something that was said later to a victim advocate, to you or like to a victim advocate, would be if the officer didn't ask the question on the night of. And so this is one thing where they probably, weren't asking this question before ODARRA. And I usually point that out. I'm like, okay, this one and some of the ones about the children, these are new questions to ask. But this is one of the lethality factors that the victim is pretty sure this is going to happen again. So now we get to the last 5, which are more about the dynamics of what's going on in the house or in the relationship. And this one is if there's more than one child. So that is all living children of the victim, the offender, and any children they have together. So it counts his kids, her kids, and their kids. So if there's more than one child, you would score this a 1. And the thing that's hard for the officers here and a lot of people is you also count minor children or adult children, even if they live somewhere else. And you count biological or adopted children, even if they're 30 years old. So that's the one caveat about this is it does count. And we give the officers cheat sheets, that have this, that kind of remind them of this criteria that is both minor or adult children, because that's what the research showed. And I think, you have worked with enough cases that how much the children can be a part of the dynamics of the relationship, whether they're kids or adults. They're still part of what happens. So this one, people who don't work in the DV world don't understand, but people who do immediately get it usually, is you count the victim's biological minor adult children with another partner. So these are not the biological kids of the offender. And that makes perfect sense, right? Why does that make sense? Amy, I see you nodding. Why does that make sense?
It's usually a problem.
Yeah,
in the relationship.
And it's a constant reminder that she had a relationship with somebody else, and it's not his kid. So you count the victim's biological minor or adult children. You count all living with the victim or living elsewhere. This is one where you don't include children adopted by the victim because it doesn't have that connection to a previous partner. So basically just the question is, do you have a child from a relationship? And this is one of the lethality factors also. So 10 is the one that I mentioned earlier. 10 is identical to 2, except there does not have to have been a police report. So if the victim says, yep, he got into a bar fight or he got into a fight with his brother last Thanksgiving, you would count this. And sometimes the questions comes up from the officers, well, what if she's making this up just to get him in trouble? And my answer to that is usually, well, you as law enforcement officers have to assess the credibility of information all the time. And I would just ask you to apply that same critical assessment to this as well. So if number 2 has been scored a 1, number 10 is always scored as a 1, but not vice versa. Because if law enforcement didn't come, you wouldn't be scoring number 2 a 1. So now we get into the last 3. This one is indicators of substance abuse on the part of the offender. And there's a whole list. And because we know that while substance abuse doesn't cause domestic violence, it often co-occurs with it. So it's often present. The developers of the tool found that at least 2 of these had to be present in order to score this one. So the one I want to point out to you are these 2, and that is consumed alcohol before or during a criminal offense, and then the one after that, alcohol problems since age 18. Because what we found and what we were trained to recognize is that an OUI counts both of those factors. So if somebody has an OUI on their record, you would always score this a 1, because they consumed alcohol before or during a criminal offense. And here's the definition of problem. Problems include alcohol or drug use related to a law violation. So OUI always counts. And if there's both alcohol and drugs involved in on the part of the offender, you might get your 2 that way as well. But the one we see most often are OUIs. Or if the offender was visibly intoxicated at the scene, and then there were one of these other factors involved. We talked about that already. So number 12 is assault on the index victim when she was pregnant. So this could be, she could be pregnant during the current assault, or it could have occurred in the past. The offender doesn't have to know she's pregnant, but she's pregnant and she's been assaulted. And this is also a lethality factor. Unfortunately, I mean, you may have seen this in your work. Sometimes some of the first physical assaults happen when the victim is pregnant, which is pretty awful, but that's what the research shows. So, assault is the same definition. Information can come from the victim. And the officers are trained to ask, has your partner ever assaulted you when you were pregnant? Pretty straightforward. The 13th one is really interesting. I like the way it is phrased because it elicits some information about factors that make it harder for the victim to leave a relationship or get support, but not in a way that's victim blaming. So any one of these things could lead to this being scored a 1. Children aged 18 or under who live with the victim and for whom the victim provides care. No cell or landline telephone, and that's where that situation where somebody stomps on the cell phone happens. The victim doesn't have a phone. I mean, she might be getting one in a couple of days, but she doesn't have one when this is scored. And we know this is a real dangerous time right after somebody's been arrested. No access to a vehicle or public transportation. Victim lives in a geographically isolated area. And I know that, that happens in a lot of your cases. And this final one, alcohol or drug use by the victim just before or during the incident, or a history of alcohol or drug abuse. So this is not meant to blame the victim, but it is recognizing that if the victim has a substance abuse issue or was using alcohol before the event, the research showed that it made it harder for her to get support and leave the relationship. Those are the 13 factors. I'm going to PDF these slides and send them to Kara so she can share them with you. So you'll have this. Those are the factors. Now, the next thing, I want to be mindful of the time, because I want to save some time at the end for you to think about how you might use this information. So if it's unclear or ambiguous, the officers are trained to score it with a question mark. And the example I gave is, if you can't tell if it was a DV assault, you might be able to, if you dug deeper into the record, you would score it a question mark. And it is more accurate than if you guessed or scored it a 0. If there's no evidence of any prior assaults, it would be a 0. It's only if there's something present. If the victim says, well, I know he got convicted of, some kind of burglary or assault in the past, and you can't tell if he got a sentence of 30 days or more, that one might also be scored a question mark if you don't know what the sentence was. So, and in those cases, there's a chart that the officers have that, so on the left are the raw scores. So if there are 3 1s, and then there are 2 items where there are question marks, the final score is a 4. The raw score is a 3, the final score is a 4 using this chart. So this is the key part of ODARRA right here. And I'll explain what all these things are, and it's pretty straightforward once you see it. It's really key. So let's look first at those black bars. On the left is how likely they are to reassault. On the bottom is their ODARRA score. So the score can be anywhere between 0 and 13. So if it's a 0, they are roughly 7% likely to reoffend seriously and blah, blah. If it's a 7 or higher, they are 74% more likely to reoffend seriously, sooner, and with more serious consequences. So when I talk to law enforcement and bail commissioners and judges about this, it's like, wow, wouldn't you like to know whether you have a person who has a 0 or whether you have a person that has 7 or higher? So the crosshatch bars are subsequent research. It kind of shows that it's the same. And you can see it's a nice linear increase. The line across with the little squares on it, that shows how many people fell into each category and the total number of the was over 1,400 in the study. The original study was about almost 600, but then there were some subsequent ones. So generally, it's a little bit like a bell curve. There's a fewer on the end, on either end, and a little bit higher in the middle. What's interesting is that we've had a study by somebody from a university in Arizona, a 5-year study on ODARRA from different parts of the state, of the country, but including about 8 departments in Maine. And what she found was that ODARRA was quite predictive, as it was supposed to be, but that the line was a little more straight, a little more of a straighter line. That it didn't have quite as much of a bell curve in Maine, which was kind of interesting. This is also really important for you to know, this particular slide, and it is the 3rd bullet. The details in the narrative have to be consistent with and directly support the ODARRA score. Because what we found out is that if you have a sharp defense attorney, they have been successful in using the inconsistencies to undermine the credibility of the officer in the trial, in the case in chief. I mean, normally ODARRA score would never be mentioned in a trial because it doesn't have anything to do with whether somebody committed an assault or didn't commit an assault. It only has to do with predicting subsequent assaults. But there have been some cases where the defense attorney said, well, look at this ODARRA score sheet, you said this, and then in your report, you said this, which one is it? And so it undermines their credibility. So for you, kind of if you look over this stuff, if you spot inconsistencies like that, it would be good to talk to your, whoever the ADA is who's going to be handling the trial, because that opens the officer up to attacks on the officer's credibility. So that's something we learned from talking to people around the state. So the score should be, the ODARRA should be scored and signed by a single person. It should document the eligible crime, the eligible relationship, and the scoring. And the report should include both the raw and the final score. And when we do this, and we talk to the officers about scoring, it's really important to have not just the final score, but what were the items? Because as you might imagine, the interventions, whether it's at a high-risk team or sentencing or probation conditions, they're going to change based on where the scores ended up. You know, if this is somebody with a long criminal history, substance abuse, and a record of violating court orders, that's a different intervention from somebody who's got a substance use disorder and a lot of kids. So we ask the officers, don't just give us the final score. We need the full score, because it depends on the intervention, you know, what intervention we're going to be. So this, you know, when we did this, when MCEDV did this, these are some of the things they found out. More high-risk offenders were being identified. ODARRA is increasing communication about risk. It's elevating offender risk management and enhancing victim safety planning. It's had a clear impact in Maine since it was implemented 6 years ago now. This was somebody, law enforcement officer who's a national trainer, has been for a long time, a retired law enforcement officer. And he described ODARRA, he mentioned Maine in this article, and he said, these methods are, you know, the future of intelligence-led policing and their future for first responders. This is the study that I mentioned, that in Maine, ODARRA is predicting future rearrest in a manner consistent with the previous information. I wanted to just take this and kind of go over it, because for me, it describes kind of the difference between when I was in the DA's office and we were just starting to recognize DV cases and subsequent, and what's happened post using ODARRA. So if you look at this case is defendant pushed his wife across the room, causing her to fall. He grabbed her, wouldn't let her leave. He threatened to kill police if she called. She's pregnant. She's got 2 other kids, one of whom is not his. She's afraid she might be hurt again. His criminal history included an OUI and an assault from a long time ago. She now kind of wants contact because she needs help. So what do you see here that might be ODARRA factors? Because basically this is a push. When I was in the DA's office, we didn't even charge these. This is a push. And the guy's got a little history, a long time ago, assault and an OUI. This is a push. So what do you see that are ODARRA factors that would raise the risk in this case?
She's pregnant.
She's pregnant.
She's got
What
2
else?
kids, one without, who is not the defendant.
Non-bio dad. Yep.
He grabbed her, wouldn't let her leave.
Right. Confinement. Yep.
He has the DUI, which is
He's
a
got
factor.
the DUI, so he's got the substance abuse. We got a
Prior
prior.
assault.
And a prior assault, yeah.
Got a prior. Yep. So you've got all those. And what the score looks like is this. You got a couple of question marks because we don't know if that assault was a DV assault or not. You didn't have any prior sentence, but you had a threat to harm, you had confinement, you had victim concern, you had more than one child, bio child from a previous partner, substance abuse because of the DUI, assault on her when she was pregnant, barriers to victim support because she's got these kids who are minors that she's taking care of. So from a case that was a push with a couple of prior, with a couple of things way in the past, you have an ODARRA score of 8 or higher, which is, the highest possible score for future assault. So this, when I did this for law enforcement and for the judges and stuff, they were like, huh, so it provides a bigger context in some of these cases, and more discussion about risk. So just looking at the time, I'm going to talk a little bit about how ODARRA is used in Maine, and then I would love to have your thoughts about how you've seen it used or how you maybe would like to see it used, or how it affects your work. So it's definitely used for bail recommendations, victim advocate referrals, resource allocation. So if somebody, we look at the ODARRA score in Cumberland County when somebody gets put on a electronic monitoring, if they wear an ankle bracelet, or maybe they get some kind of an alarm system, the victims get an alarm system. Referral to the high risk teams and GPS monitoring. Helps make a pretrial, looks at these, Maine pretrial services looks at these. And this is the point I made, individual items should be reported so appropriate conditions and can be determined based on that information about risk. Courts use it for setting bail. They sometimes use it for sentencing. They use it to determine if somebody is going to go to, and it's known as DV court or judicial monitoring, depending on what part of the state it's in. But the offenders have to come back, and even though they're also on probation or maybe under deferred disposition, they have to report back to the judge about whether they're complying with their conditions of release or not. Probation might supervise them more intensely. They might check in with them more often. So their level of risk is higher. Victim services, I know our victims use it to refer ODARRA cases to our high risk team. But I made this point, the third point, last week when we were talking, because it should never be used to refuse services. If somebody's got a low ODARRA score, as we've talked about, there may be other reasons for that. Maybe you don't have all the information, the officer doesn't have all the information. Maybe there's a lot of lethality factors that are present. So victim services are really careful not to use it to say, well, they don't need our services because the ODARRA score is low, and we make that really clear. Also, they should never be used to determine whether somebody gets a protection order or not, because they don't have anything to do with whether the abuse occurred. They might have some use in determining appropriate conditions of that order, but never whether they should get one or not. So I want to spend a couple minutes on high-risk response teams. How many of you have these in your jurisdiction? Okay, Amy's got one. Okay, Jamie's got one. So they are based on the Jeannie Geiger Center in Massachusetts. It's a research-based model by which people get together, and Valerie says she doesn't think so. Good, because she's not on my screen, so it's hard to tell. So thanks, Valerie, for popping in with that. So it's where people who are making decisions about these cases get together and talk about high-risk cases on a monthly basis. So in our case, it's our DAs, our victim witness advocates, our DV advocates from Through These Doors, Maine pretrial, probation, and somebody from the jail, and our law enforcement, of course. So they get together on a monthly basis. And, for the last year and a half, we've been doing it on Zoom, which is actually easier for people to do that rather than go somewhere. And we talk about 3 or 4 or 5 cases that have been referred based on either their ODARRA score or the lethality factors in the case. And they talk about, when is the next court hearing going to be? Is the person in jail or out of jail? What are the bail conditions? How can we better protect this victim? How can we intervene in this case? How can we, maybe the officer is going to do more drive-bys. Maybe they're going to, sometimes the DA's office, you haven't heard from the victim, but somebody in the DV agency has, and can talk to the victim about, hey, DA's office needs to talk with you. Can we connect you and the victim witness advocate to, to tell so that you can learn more about what's happening in a criminal case, or vice versa. And obviously everybody has to have their releases in terms of whether, they're going to talk about this information. The DV advocates do, the community advocates do, about who's going to be at this meeting and what are we going to talk about. But it is really astonishing. So our project has been together, as I said, for over 20 years. But even with that, and we have pretty good relationships. It was astonishing to me when we started this team 6 or 7 years ago now, how much information wasn't being shared. You know, and some of it's, you know, Maine pretrial or whoever's making decisions about whether somebody's going to get out, they get a lot of information from the other people around the table that help them decide, is this person going to be a good candidate for pretrial release and supervision or not? So it's been, the research out of Massachusetts has been, you know, their homicides dropped significantly. There's a lot more communication, and we've certainly found that. In one situation, and it just happened to be a case where our district attorney was present. This was a few years ago. The victim, so had been a serious, you know, long time violent relationship, and the victim had been really scared to participate in the process on many of the previous arrests. So the victim advocate, in talking with the victim, found out that there was a whole series of threats against the victim in these prior cases and the current case. So the victim advocate came to the meeting with a stack like this of written threats that the offender had made to her. So that, you know, changed the whole discussion to have that information as part of the discussion. So it made it, you know, everybody was much more informed. So that's one of the things that we do with the information. Sticking here. Let's see if I can get this to. Okay, there we go. Oh, last one. Perfect. So I wanted to leave time for questions and your thoughts about, you know, how ODARRA, how you can use it, how you have used it. Whatever your thoughts are, to take this next, you know, few minutes to answer questions or talk about it.
So when you're scoring it, Faye, do you go up to the 13 or?
Yes, definitely.
And then just go back to a raw score or a total score of +7 or
Nope.
7+?
No, you score the whole thing. And you would put, if there's a score of a 12 or a 13, everybody making decisions wants to know that. Because there is a difference. There may not be a difference in how likely they are to reoffend. So that's going back to your, if it's 7+, if it's 7+ or 10+ or 13, it's the same likelihood of reoffense. But your decisions about intervention are going to be different for somebody with 7 factors than somebody with 13 factors. So you keep scoring it. The only time when that 7+ part comes into effect is when you're sort of interpreting the likelihood of future risk.
That's one thing I was going to mention is I don't know that that's clear. You know, for us, when we're inputting, and I don't know if any of the other VWAs do this, but in our database system, we are required in all domestic violence cases to enter the response to question 1 and the actual ODARRA score. And I can only imagine that's for data collection. And there is 1 through 13, but I've seen folks that just, you know, because it says 7 on the paper, that they're just putting in 7. And I have tried to suggest, you know, and I think for those that I have contact with, it becomes apparent why it's important. If it's a 12, it's a 12 that we're entering in there.
Right.
But I see law enforcement a lot of times, you know, just mark that 7+. Yes, we usually get 2 different forms. So I usually see the questions and the 0 or the 1, and I can see what the actual raw score is. But I do very often see there's just a 7+, and never anywhere does it actually indicate what the true number is. And not only that, but it's very rare for me to see any reference to the score in the reports.
Interesting.
Which I know isn't a requirement, but sometimes I do see it and I'm like, oh, that's interesting, you know?
Yeah. Can be helpful, you know, and it can be helpful down the line too, in terms of people who are using the information down the line, because it was developed to be used down the line. So, you know, I think it's even helpful. There's a new statute that goes into effect next week that Karen knows about, and I know has been working on procedures, but for the DA's office to provide the police report to the batters programs, now called DVIPs. And I mean, it's helpful for them to know, you know, and it may be even helpful to know, for them to have like, to know where the scores came from. And it would certainly be helpful for them to know if the score was a 7 or a 13. So it is, you know, that's really helpful information, Jamie. I appreciate hearing that, so that we can really stress that in future trainings, and maybe even get Brian McMaster or somebody to send out a little thing that says, don't stop scoring. Put down the true score. Don't stop at 7.
The other question I have, Faye, is our system doesn't differentiate the type of relationship. So JustWare requires me to enter an ODARRA score, despite the fact that they may not be the appropriate fitting relationship for ODARRA.
Yep.
And there is a not available, but I worry about putting that, you know, I mean, I'm assuming if they're collecting data, that not available makes it look like law enforcement just didn't do it, because there's no way to differentiate between it's appropriate to be done and it's not appropriate to be done. So in every domestic violence assault case, I have to enter some, because it will give us this orange flag and it won't let us close the case.
Yep. So there's no score, no place to mark not eligible.
Right. That's not a drop down. I mean, I could put it in the notes section, but I doubt that the folks that are collecting the data actually get the notes. I suspect they just get sort of, you know, the information that and it is a drop down. It's, you know, for example, there's a question that asks the score for question number 1, and it's 0, 1, or not available. And then the second question that we're required to answer is the score, and it's 0 through 13.
Mm-hmm. So I'm going to pass that information. That some of those changes in JustWare came as a result of a sort of a joint of a stop grant that kind of added those. And some of the folks from MCEDV were part of the group that designed that additional information. So I'm going to mention that to them so that they can, in terms of, especially both in terms of interpreting the data that they have, and potentially in terms of adding another drop down that says not eligible.
That makes sense. Another just observation of mine, because I do the domestic violence cases here in Androscoggin County, is that I do see law enforcement doing them for DVK. It's just sort of an expectation that they're done for all domestic violence cases. So it's really helpful for me to have more clarity on that and be able to share that.
Yeah, absolutely. What I can also do, Kara, I'm going to send you a PDF of the slides, but I'm also going to send you what we call the cheat sheet. It's the quick score, because we have it front and back, and it has all the ODARRA things listed, but it also has remember, this one is adult children too, and this one is just minor children. So it has all those little, this one has to be 30 days actually served, you know, or actually ordered to be served. So so that might be helpful. And it has on the top of it, eligible relationship and eligible charges.
Yeah, that's great, Faye. You can definitely see some of the ways that the VWAs keep the train moving. Right.
Absolutely. Absolutely. Well, it's been really helpful to talk with you and you know, learn about some of your experiences with it too. And if you have questions, or Kara, if you want, you know, sort of more information about the high risk teams and how those operate, and how, I mean, actually in Cumberland County, when ours started, it was actually one of our VWAs who kind of took the lead, because she was familiar with it from another jurisdiction, and she took the lead. I mean, and she worked in partnership with someone from the DV agency.
Great.
But so, you know, I'm happy to, but I've been to several of the presentations by the Geiger Center, and we have a list of protocols, written protocols that actually went to the DV and Sexual Assault Commission and have been approved, kind of. So that's helpful too. So if
Yeah.
there is, interest,
Right.
happy to answer any questions about that.
Absolutely too. And I just in closing, I think one of the things that we didn't cover as much today, but I'm hoping that this is helpful information for is, VWAs thinking about the kinds of conversations that you have with victims about, the nature of the case and to help provide some of this evidence-based information like the lethality factors that can help support their decision making. Because
Exactly.
we see so often that for a host of reasons, including just the nature of coercive control, that victims might not fully appreciate the risk of reoffense or lethality.
Exactly. I'm going to send you one more thing, and it's basically, that bar graph I showed you. I actually have the same thing like in pie chart form that was specifically developed by Zoe Hilton and her crew for people to sit down with victims and say, this is, if your person's score is a 2, here's where you fall. But if it's a more than 7, then you've got a pie chart that's 3/4 full. And what we have heard from our victim advocates and victim witness advocates is that quite often the response is, whoa, I had no idea. So it's a way for them to view it through a different lens, through an objective tool, that allows you to sort of, instead, you say, I'm worried about your safety. And then you can say, and here's why, and this is how likely your partner is based on this tool that we use in Maine to reassault and more seriously, especially if the score is more than 7. So I'll send you a copy of that pie graph too, because that's useful. It's more useful than that bar graph that's kind of confusing.
Perfect. Well, thank you so much for your time today, Faye. This has been really informative, I think, for all of us. So thank you.
Yeah,
Great.
thank you.